Hey everyone, and welcome to this explainer. Today we're going to demystify the sheer immense power of India's highest court. Now, we often just think of the Supreme Court as this grand building where laws are debated, right? But it's so much more than that. It's actually a highly dynamic institution equipped with what I can only describe as a massive arsenal of constitutional powers. It acts as the ultimate guardian of democracy. So let's just dive right in and unpack exactly what makes it so incredibly powerful.
Okay, before we get into the nitty-gritty legal mechanisms, we really need to ground ourselves in the solemn constitutional authority that underpins this entire judicial system. You've seen the state emblem, accompanied by the famous words Satyameva Jayate, which means truth alone triumphs. That sets the perfect stage for us. Literally everything we are about to discuss today stems from this one core principle, that truth and constitutional righteousness absolutely must prevail. And the Supreme Court, well, it's the ultimate vehicle for that truth.
So here's our roadmap for today. We're going to break this complex toolkit down into 5 escalating tiers of power. We'll start with the court's seat and fundamental authority, then move into original jurisdiction, explore how appeals and special leave petitions work, look at the extraordinary power of complete justice, and wrap up with its role as the ultimate guardian. Let's get going.
Starting off with Section 1, the Supreme Court's seat and power.
Now, Article 129 is fascinating. It officially designates the Supreme Court as a court of record. What does that actually mean in practice? Well, it means its rulings are basically etched in stone. They are permanently binding. A lower court or even a state legislature cannot just casually alter a Supreme Court ruling. And crucially, it inherently holds the power to punish for contempt. This isn't just about demanding respect, it's a vital built-in mechanism to make absolutely sure its rulings carry undeniable, absolute weight across the entire country.
You know, when we think of the Supreme Court, we naturally picture its operations based entirely in New Delhi. But here's a really cool, lesser-known fact. Article 130 actually provides a ton of flexibility. With the President's approval, the Chief Justice can legally set up regional benches anywhere else in the country. In fact, the Law Commission actively recommended setting up 4 regional benches, just to make justice more accessible for citizens who live far away from the capital. But as of right now, this power remains completely unexercised, and the court remains centralized in Delhi.
Moving right along to Section 2, original jurisdiction under Article 131.
Okay, picture this. What happens when major political heavyweights clash directly? Say the union government has a serious dispute with a state, or maybe 2 states are battling it out over boundaries or water resources. They don't just file a case at some local district court. Nope. Under Article 131, they completely bypass all those lower courts and walk straight into the Supreme Court. This is called original jurisdiction. It acts as the exclusive, designated referee for the absolutely highest stakes federal disputes in India.
All right, let's hit Section 3, Appeals and SLPs. So, for your everyday cases, there are some pretty strict, rigidly structured pathways to get from lower courts all the way up to the highest bench. Articles 132 through 134 lay this out for constitutional, civil, and criminal appeals. Notice this deliberate filter system we've got here. It exists for a reason, to prevent the highest court from being totally swamped by routine cases. Generally, you need a substantial question of law and formal certification from a high court to even get through the door. It's a very strict ladder you have to climb.
But wait, what happens when those regular appellate doors slam shut? What if a high court simply refuses to give you that necessary certificate to appeal? Well, enter Article 136, the special leave petition. Most people just call it an SLP. This is a discretionary power that lets the Supreme Court grant leave to appeal against absolutely any judgment from any court or tribunal in India, military courts being the only exception. Think of it as a discretionary VIP pass for justice that slices right through the standard red tape.
The contrast here is honestly wild. Standard appeals rely heavily on high court approval to move forward. The high court acts as a gatekeeper. But the SLP, that is the Supreme Court's very own overriding discretionary trump card. If the Supreme Court looks at a case and feels that a gross injustice has occurred, it literally does not matter if the High Court said no. The Supreme Court can just pull the case up directly. It exists to ensure that absolute justice is never blocked by a mere procedural technicality.
And you know what's really great? The Constitution acknowledges that, hey, even the most esteemed judges in the land are still human.
Mistakes happen. So, Article 137 equips the court with the power to review and correct its own past judgments. If fresh, compelling evidence suddenly comes to light, or if someone spots a glaring procedural error after a verdict is given, a review petition allows the court to look at its own ruling again and fix it. It's an absolutely vital mechanism for self-correction.
Now for Section 4, the concept of complete justice under Article 142.
All right, this is where things get incredibly powerful. Article 142 is a truly sweeping provision. It empowers the court to pass any decree or make any order necessary for doing complete justice. Think about the scale of that for a second. If existing statutes and laws fall short, or if a totally unprecedented situation demands a remedy that simply isn't written in any law book yet, the Supreme Court isn't just stuck. It can invoke Article 142 to go completely beyond regular statutes to ensure fairness. It's essentially the ultimate legal safety net for the entire nation.
And that brings us to our final section, Section 5, the Ultimate Guardian, covering Articles 141 to 143.
Under Article 141, the word supreme literally means supreme. Any law declared by the Supreme Court automatically becomes binding on all other courts within the territory of India. Once they interpret a law or establish a brand new legal principle, it instantly becomes the absolute law of the land for every single high court, district court, and tribunal below it. It's the glue that creates a unified, cohesive judicial system.
Finally, the court also holds this immense advisory power. Under Article 143, the President of India can actually consult the Supreme Court on highly critical legal or public matters. If the executive branch is facing a really complex constitutional headache, they can proactively ask the court for its expert opinion. Now sure, this advice isn't strictly binding on the president, but let's be real. Coming from the highest court in the land, it carries massive legal and moral weight. Wow, right? We've just walked through a massive, escalating arsenal of constitutional powers, from its unshakable status as a court of record, to its exclusive jurisdiction over fighting states, to those discretionary VIP passes we call SLPs, all the way up to its extraordinary ability to guarantee complete justice. So I want to leave you with a final thought to ponder. Given everything we've just covered, are the powers of the Supreme Court sufficient to truly ensure complete justice? Think about how these incredibly structured powers shape the everyday reality of democracy and fairness in India. Thanks so much for joining me for this explainer. Keep questioning, keep learning, and I'll catch you next time.